How are you going to prep for that real estate exam that you're preparing to take? Well, you're going to prep with lots and lots of questions. And of course, the vocabulary. First of all, before anything else, is learning your vocabulary and practicing lots and lots of questions every day. And I highly recommend that you repeat taking the same exam until you ace it. What I mean is get 100 score on it and put yourself in a nice, comfortable area with put your special cologne on so you feel good, you smell good, have your water next to you. So we've got to keep ourselves hydrated so we don't get stressed out. And you can also have a diffuser with a nice scent and some music in the background. So just some tips in preparing for that real estate exam. All right, so we're continuing from Saturday's session, and I go consecutively with all the questions from the real estate book. This book is what I'm using right now, Texas Real Estate License Exam Prep by Metling, Father and Son, Cusick, and Hamilton. They published this book in 26 states and adding every year. And we'll have a new book for Texas sometime later this year. It's excellent because it gives you a review of all the topics that you studied. It gives you lots of questions, and it explains the answers. And that's what's really important to help it make it a little easier. And for yourself, hey, set a schedule so you don't get it really stressed, okay, and get discouraged, and do it every day. All right, here we go. And at any time that you have questions during the class, hey, feel free to ask and participate. So the class is designed for everyone to participate during the class, and I can help you if for some reason you get an answer incorrect. And then I'll explain it to you. So this is a time to take a risk, all right, instead of waiting until you have the actual exam. Take action, okay? Step up to the plate, all right? Because when you get in the real world, you're going to have to be interacting with a lot of people and taking a lot of risks, right? Because you're not going to know everything after you pass the exam. So do it now while you're practicing and preparing. Okay, here we go. And anybody watching the replay, hey, you can fast forward it, up to 2 times speed if you can still keep up with that, because I do allow students to answer the questions in between. All right, I moved it. Okay, what number were we on? Excuse me. 332. I was on the right place. And if you have the book, you can follow along with me. And if you don't have the book, you're able to buy it if you'd like. And it's on the description, in the YouTube description, on the video description. All right, number 32. A real estate sales contract to be enforceable must be what? A, contain a legal description of the property. B, be written on a form approved by the state. Oops. I need to share the screen. There we go. Pardon me. So let me start again. A real estate sales contract to be enforceable must be what? A, contain a legal description of the property. B, be written on a form approved by the State Bar Association. C, be acknowledged by 3 witnesses. Or D, be recorded within 3 days to be enforceable. Type your answer in the chat. Think about it before you type the answer. So there are very specific items that are required in a contract to be legal or to be a valid contract, an executed contract. What is one of the most important things that must be on there? We know that it has to have a start and an end date, but they're not mentioning that. So what else could it be? Contain a legal description, be written in a form approved by the state bar. Who creates the promulgated contract? Not the state bar, but several attorneys. So type your question, type your answer in the chat, type the question number and the letter answer, please. So going once, going twice, gone. The answer is A, which is contain a legal description of the property. And on Saturday, we talked about legal description in the answers. And if you're not familiar with that, go back and review your vocabulary, legal descriptions of the property. Because, you know, who creates the promulgated contract? The 13-member committee, or at least that's in Texas. Okay, so every area has their own committee that creates the promulgated contracts. Today is the 6th, right? My YouTube and my Facebook are not synced. Oh, and I just want to make a comment that if you're watching on your computer or on your phone and the resolution is not good, you can go to the bottom of the screen, usually on the lower right-hand corner, there's a little gear. When you click on the gear, you can select high resolution, select 1080 or 720, and it'll become clearer. Okay, so Miss Page, hi Page, and hi Facebook user. Who is that? Is that Miss Lisbeth? Well, hello, Miss Lisbeth. No, the answer is actually, you don't have to be acknowledged by 3 witnesses. No, that's not. The sales contract is between the seller and the buyer. What it must have is a legal description. And what that is the description of that particular property, because every single property has its own individual legal description, how it's identified in the county records, within the contract, in the title commitment, which is the title search, in a survey, and the deed, the warranty deed, and the deed of trust or a mortgage. So it's used in so many areas and so many documents. So it is the legal description that is needed in a sales contract to be enforceable. Well, hello, Miss Lisa. How are you? Thank you for joining us. So we are doing national questions that apply to all 50 states. Wow, my YouTube is not refreshing. It says I haven't started yet. Today is the 6th, and it's after 6 p.m. All right, why is that doing that? Are y'all being able to watch it on YouTube? You must be, but my YouTube, great, thank you. So my YouTube is not letting me see your comments. It still says waiting to go live. So Lisa, and who else is on Facebook? Paige, you're able to see it, right? You see my screen? Yes, ma'am. All right, awesome. Thank you so much. All right, number 33. How much time does a seller have to accept a buyer's offer? Every state is different, but this is a generic national question. A, 48 hours from the time of the offer or signing of the offer. B, 24 hours from the time of the offer's delivery to the seller. C, within 24 hours following the stated expiration. Or D, a reasonable time or until the expiration date on the offer. So every state is different, right? Some states may require a document that says, hey, you have to reply in 24 hours, 48 hours, 72 hours. That's what I dealt in Oregon. However, in this one, it is a general question for all states. So you select the best answer. And it is not B, as in boy. Take another attempt. So how much time does a seller have to accept a buyer's offer? 24 hours is really limited, unless they have an addendum that says, seller, you've got to respond in 24 hours. But that is not a must, okay? The actual, shoot, I like that. Shoot deep, don't shoot me. So yes, the answer is D, a reasonable time or until the expiration date on the offer. So that some contracts could have an expiration date, like I was stating, an addendum. If it doesn't, like in Texas, we don't have that, then it is a reasonable time. Now, if the seller doesn't reply in 24, 48, 72 hours, and the realtor says, hey, they're looking at it, then it doesn't look like they like the offer. You might have to do another offer, but it's always good to touch base with the realtor representing the seller to see why they haven't replied. So it is the buyer's responsibility and their realtor. And so, hey, Paige, hopefully your glasses are not on your head, right? Because a lot of times when I look for mine, they're on my head, right? All right, just being comical here. So yes, that makes sense. It's at a reasonable time. And you might say, okay, well, what's a reasonable time? Like I mentioned, if it's taking more than 24, 48 hours and the realtor hasn't given you an update, then your realtor should be proactive and follow up and ask, right? Because it's between realtor and realtor that offers are dealt with, right? Not from seller to buyer. No, they were in your purse. Got it. Sometimes mine are in my head, on my head. Like sometimes looking for the pencil. I used to be an engineer. I'd have a pencil on one ear and a pen on the other. All right. So 33D. Very good. Number 34. Let me make that a little bit larger in case anyone is watching on their phone. Well, that didn't work. All right, number 34. A buyer submits an offer to a seller and then dies in a car accident. That's unfortunate. However, it does happen. Before learning of the buyer's death, the seller accepts the offer. Which of the following is true? A, the seller can force the buyer's estate to go through with the purchase. B, the buyer's death terminated the offer. C, the seller must make a new offer with the same terms to the buyer's heirs. Or D, the buyer's heirs have the option of enforcing the contract. So remember, contracts are between one individual and another individual or multiple individuals on a side or entity to entity. So what could happen when someone passes away? In a contract, okay? In an offer. All right, so far we've got B. B as in boy. We're typing the question number and your answers. That way we're all on the same page. And yes, the answer is B as in boy. The buyer's death terminated the offer. Now there's an agency relationship, right, between the buyer who passed away and the real estate company. Now, if it was a rental and there's a lease agreement between the landlord and the lessee dies, well, they were under a 12-month contract or agreement. Leases are called agreements, but it's still a contract, right? So in that case, the estate is still responsible for paying the monthly rent for the remainder of the lease. That is different than in a purchase sale contract. Very good. Y'all did awesome. 5. Which of the following contracts can be signed to another party? So what happens here, there can be someone that is writing a contract with a seller. Okay, so what kind of contract, which of the following contracts can be assigned? A, an exclusive listing agreement, B, a personal services agreement, C, a contract for the sale of undeveloped land, or D, an employment contract between a broker and a salesperson. So which of the following contracts can be assigned to another party? Meaning one individual, a buyer, put it under contract to a seller. And so which type of contract can that buyer that put and or assign to on the contract, which of the contracts would be valid to do that with? Chatty chat chat. And if for some reason I ever get kicked off of the live, I will come back on. So just be patient. And if you may need to refresh your screen, okay, in order to get back on the live. Because right now my live is not happening on YouTube. Okay, so we've got we've got DD. It is not, which question? We're on number 35, right? It is not D. Yeah, YouTube, and it sometimes I'm using StreamYard in order to stream to different places. So I'm streaming to, so I'm going to shut it down and reopen it, because that way I know if y'all are responding. Also, I also see it on StreamYard. All right, let's B, but it's not B. The actual answer is a contract for the sale of undeveloped land. So the types of contracts that it's any type of contract. And so the person that does this is typically an investor, a wholesale investor. So what they'll do is they're looking for properties to then assign the contract a buyer. They don't represent either party. They're tying up the property with a contract, and they can write on there, when they type in their name, they can write Joe Blow and or assign to. So they present this to the seller, they tie up the property and go get the buyer. And then they assign and when the buyer agrees, they will pay them a fee, okay, for that contract. And they will get it at the closing. So then that the investor, which are wholesalers for the most part, they will assign that contract that's already been executed to that buyer. Do you all follow me on that? So that is any type of contract, a residential, commercial, land, multiplex units, new construction. So they deal with buyers that, want to invest. It's typically for investment buyers. But it can be a buyer that's going to live in it. So for properties that are being sold for sale by owners, they put it on contract and then assign it to a buyer. So they are not representing anyone. All right, and B and D. All right. You got them all there, but C, right? So A is an exclusive listing agreement. No, listing agreements are not transferred, okay? They are not assigned to anybody. If the seller wants to end the listing, it is terminated, okay? So listing agreements are not assigned to anyone. They are the owners of a particular property, unless they have an executor, an administrator that's assigned by the court because they went into probate. And let's see, what else? Oh, and then you have, banks that also do real estate owned property, and they list them with realtors. So no, listing agreements do not get assigned. Now, personal services agreement, neither. Now that's a service agreement for, let's say, like a home warranty or the AC or termite, treatment, things like that. It depends on whether it can be transferred. It's not an assignment. It would be transferred if it allows it on the agreement. And the last one, D, an employment contract between a broker and a salesperson. No, that is between the broker and the salesperson. Here we're talking about assigned contracts that are dealing with purchase and sale. Okay, so the independent contractor agreement, okay, that is between the broker and the salesperson. That cannot be assigned, right? Your name is Paige Humphrey and you're the realtor. So how could we assign that to another realtor? One or another person? They would definitely have to be licensed, right? No, that contract between the broker and the salesperson will end. Those are not assigned, okay? The only one that can be assigned is a legal contract between a buyer and a seller. And it can be residential, 1 to 4, multifamily. Well, actually, multifamily will fall under commercial, farm and ranch, agriculture, which would be unimproved land, which is like this, undeveloped land. All right. So yes, that is 35. Do y'all see that? Because also all of you, I believe, missed that one. Understand that. Only resale or actually can be us to someone. None of the others can. So I would go to your vocabulary, look at contracts and assignment of contract. Okay, look at contracts. Where can implement it or used? Only with contracts that are between a buyer and a seller. At least in our business. Okay. Number 36. Yes, ma'am. Yes, Miss Page. So my screen is freezing and so is my YouTube. So it's not just YouTube. Okay. It's, I don't know, internet. And I have the fastest internet. Okay. With Spectrum. You imagine that? I'm paying a higher dollar and we test it and everything. All right. Number 36. Relationship. What kind of agency relationship? Implied agency relationship may be deemed to exist if, so what is implied? And then what is agency relationship? So those are vocabularies. A, the parties do not disavow an express contract that has expired. B, the parties, if there is a contract. C, an offering party does not receive written notice that the offer has been rejected or the promise to perform their part of the agreement if the other party performs. So what is implied? So we use it not only scroll for the, well, let me make it a little bit bigger. Yeah, it's freezing a lot. Okay. Okay, is that better, Paige? So, yeah, so Lisa, if it goes, if we go off, like I said, I'll come back on. So this is a challenging night for streaming for some reason. So implied agency, right? What is that? When we imply something, but we don't directly say it. Yepers. I like that. Where are you located, Paige? So 36. So 36. B, Lisa wrote B. Anyone else? Yeah, this is a slow night tonight. Okay, you're a Texan. Well, you live in Fort Worth, but that doesn't mean you're a Texan. So the answer here is B. The parties act as if there is a contract, implied agency relationship. So we're dealing with a client, right? Or a prospect and say, we're going to go look at properties. We're going to decide together. We're working as a team. That's an implied relationship, even though they may not have signed a buyer representation agreement yet. So, oh yeah, from Louisiana. Haven't been there a lot. But you're a Southerner. Okay, so do y'all understand that? Let's see, most of you, actually, you all got it right. Awesome. Did I type the answer? Yes, it's an understanding. That's correct, Paige. It's an understanding, right? Okay, I'm trying to show your comment on the screen so others can see it. Okay, it is an understanding. Okay, that's an implication that, oh, we're working as a team. So that we have an agency relationship, even though it's not signed yet. Okay. 6. And if you ever catch me typing the wrong answer, please let me know. I do make mistakes and I see somebody else's answer and then I type the answer even if it's not correct. Okay, number 37. Okay, which of the following is an executory contract? What is an executory contract? What is executory? A, an expired lease. B, a sale contract before closing. C, a request contract. Type your answer in the chat. Put some ring light and it dries up my contacts. The heat from the light. Number 37 is not D, so take another attempt. So when we have a contract between a buyer and a seller, and everyone has already agreed on all the terms of the contract, the realtor who last received it executes it, which means everybody's in agreement and we put the date on. All the initials, all the signatures are there, and we put the executed date. And then we send it to the title company or an attorney, whoever's going to be the escrow officer for closing. So an executory contract is actually going once, going twice. Nobody has written the right answer. It is B, a contract before closing. An executed closing is when it's already closed. But an a sale contract before closing, an executory contract is one in which performance is yet to be completed. That's executory. Once it's completed, it's executed. Okay. So just like the contract was executed, now we go to closing and it's in the executory process once it's completed. So a sales contract prior to closing is executory. While the parties have agreed to buy and sell, the buyer has yet to pay the seller and the seller has yet to deed the property to the buyer, right? Because the seller signs the deed and the buyer hands over the money. Give me the money, more money. So once it goes through the process of closing and seller signs the deed, buyer brings the money, lender, underwriter approve it unless it's a cash deal, and everything is reviewed and gets recorded. Okay, it is executed. It is completed. And sometimes it gets recorded after the funding is received. Okay, but it's done like ASAP. So if they sign in the afternoon, sometimes it'll be recorded the next day and it'll fund the next day. So once it's delivered, acknowledged, it's executed. Okay. So we had answer, let's see. A sales contract is not recorded. A sales contract is executed when both parties come into an agreement or all parties come into an agreement and all initials and signatures are on there. The realtor, after everything is done, one of the realtors will put the date of when it was executed. Then it goes to the closing department, which could be an attorney or it could be a title company. Now you understand. Okay, cool. Lisa says, yeah, it's quick. So let's see what other answers were written. Okay, nobody chose B, just C, O, and D. Okay, it is not D because D, okay, we have, in order for a contract to be in the executory stage, okay, it is not an option to buy. Pardon me with that. An option to buy goes with a lease, someone that wants to buy now with an option to actually pay for it, exercise the option to purchase it at a later date. So what they do is they write a contract to buy, but they're not going to close until a later date. They pay for an option, which is a fee. Okay, it's not a down payment, it's a fee so that the seller will allow them to live in there until the option comes due. And it could be a year. So they call it lease option to buy. So there's a purchase and sale contract, there's an option agreement, there's a memorandum, and there is a lease agreement. Okay, and the option fee in this type of situation, lease purchase option, sometimes lease purchase to buy, could be up to $5,000. And they lose that if they don't exercise the option. If they do exercise the option, sometimes the seller will put that towards their down payment. Did y'all get that? So executory, we have an execute contract, and now it has to close. So it is a contract, and it is an executed contract before closing. 30. A bilateral contract. What is? There's unilateral and bilateral. A bilateral contract is one in which A, both parties promise to do something in exchange for the other party's performance. Let me repeat that. Both parties promise to do something in exchange for the other party's performance. So performance and performance, right? B, both parties receive equal consideration. C, two parties agree to perform a service together. Or D, both parties promise to do something if the other party performs first. We could end up in a stalemate there, right? If nobody decides to perform. So in a contract, there's specific performance, right? Everyone has some type of responsibility. Like in a broker, right, and listing agreement, the broker's performance is to attract a ready, willing, and buyer to get that property sold, negotiate the contract, and get the property sold. Now, the seller is the one that actually sells it. We are helping through all the marketing, through calling other realtors and open houses and all that to attract a ready, willing, and able buyer, either through our marketing or through another realtor. So we have, and the seller is then has agreed to sell the property and give us permission to do what is required. So that's an example, okay? But it's not one of the answers. So we've got A and B. It is not B. The answer is actually A. Both parties promise to do something in exchange for the other party's performance. So each party has to perform. Seller has to perform certain things. Buyer has to perform certain things. So that is called specific performance that each party has to perform. That is a bilateral contract. It is two ways. Both have to perform specific responsibilities, specific duties. If it was unilateral, then only one party has to perform, the other one waits. And when does that happen in a contract? Can anyone tell me when a contract is unilateral? And I'll type the answer here for. So write in the chat, when can a contract be unilateral, which only one party is performing? Type it in the chat. Anybody who just came in, we are doing national questions that apply to all 50 states. Later in the evening, we'll be doing Texas state questions. So yes, the answer was B, right? Both parties, I'm sorry, I wrote B. Oh my goodness. Bad. No, you see, I saw somebody else's answer and I wrote that. The answer is A. Both parties have to perform. Oh gosh, come on. So I'm editing on Facebook and then I'll retype it here. On YouTube. My gosh, the internet is terrible tonight. Anybody want the answer for 338 is A. Both parties promise to do something in exchange for the other party's performance. Ignore my answer that I typed of B. The issues that we're having tonight, please be patient and hang in there, because the screen is disappearing on and off. All right, number 39. So did you all get that? Let's see. We had both parties receive equal consideration. No, it's just a bilateral contract means each party has to perform. Yes. Oh, so it's also terrible at your end, or is it just my end? Number 39. Sorry, I have 2 or 3 cats running around and my neighbor's dog that I bring over so she doesn't stay by herself all day long. Okay, number and VB, thanks for joining us. May I ask you to type the question number and the letter answer when you answer so that we all know we're on the same page. However, you got it correct. A. All right, number 39. A seller signs a listing agreement. What kind of an agreement? A listing agreement with whom? A broker. Then subsequently revokes the listing. What is revokes? Which of the following is true? Okay, cancels the listing. So A, the seller continues to have a contractual obligation with the broker, to the broker. B, the contract remains in full force until the expiration date. C, the broker may have a claim for marketing expenses expended during the listing agreement or the listing term. Or D, the seller cannot sign a listing agreement with another broker. So a home seller signs a listing agreement with a broker, then subsequently revokes the listing. Which of the following is true? Are they still under contract? Well, it says they revoked it, right? Yes, the answer is C. Hey, Lisbeth, you're on YouTube now. So the answer is may have for marketing expenses expended during listing term. Because sometimes there are sellers that want our services without paying for it. And for the most part, they know that should they terminate a contract or the property not sell, they won't owe anything to the realtor. A realtor has specified on the listing agreement, because of having so much experience with other sellers, just using realtors to check out the market, and then they go and sell it themselves. However, in that type of case, after we learn from experience, it charge a fee, all right, a transactional fee, and also a fee for other expenses, because some of us do professional photos, we pay for staging, we pay for power washing the house, the driveway, a home warranty during the listing. I do that as a gift, but it's not the full warranty. Or what was another big thing? I lost my train of thought. And hire, an aerial photographer, okay, a video maker. All that costs money. And if they back out after all that's done, wow, they just got a lot of free marketing. So they could be, hi, Anna, could get it to pay some marketing expenses. Everyone got that one right. Awesome. Good. Number 40. Contract. What is that? Well, that's a vocabulary, but what is it actually? What is a breach? And then a breach of contract. A termination of the contract by the mutual consent of the parties. B, financial damage suffered by a party because another party has nullified a contract provision. C, a lawsuit to force a party to discharge the contract. Or D, the failure of a party to perform according to the terms of the contract. So what if you've ever been in a legal court case, right? You probably know what a breach of contract, or with other types of contracts that we may have, right? All right, so far we've got DDD as in dog. Anyone else? There's several of you on here, so Please take a risk. This is the time to take a risk and type the answer in the chat and see how you do. Better to do it now than at the exam day. Yes, the answer is D. Awesome. The failure of a party to perform according to the terms of the contract. That is a breach of contract. So if a party defaults in a purchase and sale agreement, what the seller will, if the buyer defaults or they breach the contract, the seller will get for liquidated damages the earnest money, right? If the seller breaches the contract, the buyer can take them to court. Plus, they get their earnest money back. However, it's not automatically returned. Both parties have to sign, or at least in the state of Texas, both parties have to sign a release of earnest money. And if they don't agree, then one of them is going to deliver a demand letter to the title company or to the attorney, and that'll be sent out to both parties and see if one party doesn't answer, that means they're in default. If they do continue to argue about it, then it's going to go to court, and the judge will be the one to decide. And they'll say, here comes the judge. Yeah, here comes the judge. I don't like to go to court. I've been married to an attorney, and when he was a student and then became an attorney, dang, what they can accuse you of, even though you're innocent. You know what happened to innocent until proven guilty? Man, they're going to do a lot of stuff to try to make you feel like you're guilty. Come on, internet. Okay, number 41. All right, so everybody got it right. Awesome. Yeah, who does? No court. Yeah, I tell you what, but some people are so happy. So that's why we want to do everything legally and ethically. I'm so glad and thankful to God. I'm grateful that I've never had to deal with a legal situation. It's very important to be a detailed individual when it comes to documentation, or hire a transaction coordinator that knows how to do all that, if it's not something you like to do. But it would be best to learn how to do it first yourself, so that should the transaction coordinator make an error, well, compliance is going to review it. Okay, that's the compliance department from every real estate company that makes sure that everything is kosher and we don't have to deal with error and omissions. And we pay a fee for that. Not coordinator, I mean for E&O and for review by compliance. They keep us legal and safe. All right, number 41. What is a rescission? Vocabulary. A, the act of withdrawing an offer before it has been accepted. B, the act of declaring that a contract is no longer in effect for a given party. C, the act of declaring a contract unenforceable. Or D, the act of modifying, I was going to say nullifying, the act of modifying the terms of an offer. So rescission. What is rescission? So can you tell that the more vocabulary we know, the better we understand the questions and how to answer? Now, we're not always going to know all the answers, okay? And so at that point, you have a 50-50 chance, or you take a guess, or you look at the prior 3 to 4 questions and see what letter was answered and choose that letter. There's usually questions answered in series, not always. That's why I don't say always. And you can select that as a exam tactic strategy. So number 41, yes, all of you are correct. It is B. The act of declaring that a contract is no longer in effect for a given party. All right. Let me make sure I type the right answer here on Facebook. Very good. Question 32, and we're on 41. So we've actually done 10 questions. So would y'all like me to do another 5, or should I move on to state? Sometimes I do 15 questions in an hour. Today it was only 10 so far. So let me know in the chat if you're willing to, if you would like me to do another, 5 questions. Because I typically do the state questions after the national. And that would be, yes, please. Yes. Okay. We have unanimous for those that have answered. Very good. Number 32. Move to state. Well, I already have 2 yeses and 1 move, so we're going to do more. A valid contract must, okay, so to be valid, a valid contract must, okay, keyword must have something, right? A, reflect a mutual understanding of or agreement. B, use precise wording in a document. C, not be executable. Or D, be created only by an attorney. So how do we ending up with a valid contract? We have everybody of sound mind is for one, right? Nobody's being coerced. All right. Yes. A, apple. Yes. To a valid or to be valid, a valid contract must be reflect a mutual understanding or agreement. Come to a mutual meeting of the minds. They agree on all the terms, and the negotiation happened prior to signing everything. It's valid. Now, we also need a start date and an end date. We need the legal description. Okay, there's several, lots of other things that are required. But per the answers they gave us, the best answer. Number 43. Two parties enter in a contract. The agreement for a given the situation, it is possible that the contract may be A, void, B, illegal, C, unenforceable, or D, voidable. So it fulfills all the requirements for a valid contract, okay, with nothing disqualifying the circumstances. However, a contract is possible for it to be what? Oops. It seems like a tricky one. So far, and it is not D as in dog. Because remember, there's different types of contracts. Take another attempt. It is not D. There are some requirement for it to be a valid contract, even if it meets all conditions, all the terms. There's something else that is required for it to be enforceable. Yes, the answer is C. It could be unenforceable, right? Because what does it say? So two parties enter into an agreement. All right, so they're talking about it. Meaning that contract. Okay, because it could be a lease agreement for less than a year, right? And that would be enforceable. But given this, gosh, my screen keeps going out. Unenforceable, right? If it is not in writing. Read the answer here. So it says a valid contract that is in writing is enforceable. Okay, oral contract. So it is in writing, and in order to be enforceable, it must be in writing within a statutory time period, right? It has a start and an end. A valid contract that is made orally is also generally enforceable within a statutory period, with the exception that some contracts are enforceable only if they are in writing. And that's a large text. These laws are particular to the transfer of interest in real estate, okay, because that's what we're studying. A void or voidable contract was not a truly valid contract. So if the contract was void, then it was not valid. It could have been by somebody under 18 years old, right? Or if it was to be voidable, right, it wasn't valid. Yeah, I got that. So we had DDD. So D, voidable, it's a contract that was not valid, then it has to be voided. It's a voidable contract. You know, somebody under the age of 18 or someone that is under duress or someone that is mentally, you know, not in the right mindset, not mentally capable, then those are voidable. It might be valid, but must be voidable because of the circumstances. All right, number 44. Did y'all get that? Those of you that voidable. So there are many contracts in real estate have to be written. The only one that is oral and is enforceable, it is a lease between a landlord and a lessee, lessor and lessee, landlord and tenant, that's less than a year. All right, number 44. The guardian of a mentally incompetent party enters into an oral contract with another party to buy a trade fixture on behalf of the incompetent party. So the guardian for an incompetent, right? Because individuals have to be competent to have a contract, otherwise it'll be voidable. So the guardian for a mentally incompetent party enters into an oral contract with another party to buy a trade fixture. What is a trade fixture? Okay, it's not an attached fixture, right, as part of the house. It's not what we normally call a fixture. It's because of their profession, a dentist, a department store that has a lot of equipment that they may attach to the building, but then they have to take it. It's no good to anybody else. So buy a trade fixture on an incompetent party. A, does not meet validity requirements. B, is possibly valid and enforceable. C, must be in writing to be valid. Or D, is valid but unenforceable. It is not C. Okay, we're dealing with trade fixtures. It is not a purchase and sale of real estate. So we don't typically deal with personal property, okay, in the business of real estate. Although sometimes, they're in a lease or what was I going to say? So they're typically in a lease, okay? And so they're personal property that can be bought and sold outside of the real estate transaction. It doesn't impact the value of the property and the improvements. So yes, the answer is actually B. Is possibly valid and enforceable, right? Because it's an oral contract to buy a trade fixture, personal property. A trade fixture is personal property. It is not part of the real estate, even though it may have been attached, affixed. Right? So what makes a fixture a fixture that goes with a house? Using the acronym MARIA, right? The what is it? The method, gosh, I forget what it is. The intention, the agreement, the words that go with the Maria, how to determine, okay, how it is affixed to the property and whether it's removable or not. Something like that. I forget what all the acronyms stand for. So the answer is 344B. Is possibly valid and enforceable. Doesn't have to be in writing. They may end up having a bill of sale, a receipt. Really we don't deal with it. Sometimes it's included on the property and the seller wants to sell. Trade fixtures were left behind. The correct answer is the guardian for a mentally incompetent party enters into an oral contract. Remember, it said certain oral contracts are valid, right? With another party to buy a fixture, right? When we were talking about this question here, certain oral contracts are valid. In real estate, it's basically the less than 1 year buy and sell lease agreement. I'm sorry, the lease agreement. So oral contract about trade fixtures, it's not real estate. They're buying it on behalf of the incompetent party. So this contract agreement, it doesn't mean that it doesn't meet validity requirements. It doesn't have to be in writing. So those of you that selected C, you probably thought, well, because it has the keyword must, it's probably the right answer. Not necessarily. And is valid but unenforceable. No. Why? Because certain oral contracts are enforceable, right? We just discussed that in the prior question. So incompetent parties or parties of unsound mind may not enter into enforceable contracts. However, during the period of one's incompetence, a court may appoint a guardian who may act on the incompetent party's behalf with court approval. So let's read that again. Incompetent parties or parties of unsound mind may not enter into enforceable contracts, right? However, it said who? A guardian of the incompetent person. So they were probably assigned by the court. Method. So let me, we were talking about Maria, why the acronym to determine whether it is a permanent fixture or not. Come on. internet. I'm trying to show what Lisa wrote. Okay, so Maria stands for method, adaptability, relationship, intention, and the agreement. The agreement between the buyer and the seller. What was the intention of that fixture? What was the relationship between the fixture or the clients, and how was it adapted to the property? So what method was it installed with the property? Electrical? Well, you really need to have the fixtures there, right, to provide light and all the wiring. And a permanently installed refrigerator, you think, well, how can a permanent refrigerator be permanently installed? They go bad, right? But sometimes they, tie them down like the stoves, and those are considered permanent, right, until they break down. So a water heater, the relationship with the water heater and the house, right, is to provide hot water. So that's required. So it's not personal. It is a permanent fixture of the property. So for what B is possibly valid and enforceable because it was the guardian. And it was oral, so it could be enforceable. Number 35. A prospective home buyer submits a signed offer with the condition that the seller pay the inspection at closing. So what? A prospective home buyer submits a signed offer with the condition, contingencies, they're also called, that the seller pay the inspection at closing. So they want some of the buyer closing costs paid for. The seller disagrees, crosses out the provision, then signs and returns the document to the buyer. If validity items are in order, the original offer is now what? So we had an original offer, however, it was changed. So now what is it? A, an accepted offer, therefore a valid contract. B, executable option. C, a counter offer. Or D, an invalid offer. No, it is not D. Take another attempt, Mr. Tag or Miss Tag. Sorry, I didn't greet you. So welcome, Tag. So if you had an offer and you made a change, so it was made to the seller didn't agree, made a change, returns it to the buyer. What is that called? Yes, it is a counter offer. Very good. C, it is a counter offer. It's like novation. It's a new offer. The original offer is no longer good. Why? Because they made a change. So now it's a new offer. So now they're back into negotiation. Anytime someone makes a change to a contract, it is a counter offer. So very good for changing those answers. All right, number 36. Okay, so this will be the last national question. Okay, so pay attention. Who crossed it out? And look at the prospective home buyer. So the buyer is not represented, and the seller, so it's probably a for sale by owner, and they're using a legal contract. Well, the seller can do that, and the buyer. We as realtors, we cannot do that. If we're representing a client, we have to do it oh, I'm sorry. Let me take that back. Well, this is in Texas. I don't know about all the other states, okay? And even though these are national questions. So if let's say a seller disagrees with the closing date or with the request for buyer closing costs, there is a section that we fill in the amount. If they don't, we can scratch it out, put 0, and then it's initialed. Yeah, we're not necessarily scratching out part of the contract template, okay, the clauses. So the buyer closing costs, okay, one of the line items of the contract, which they're asking for closing costs. And if it's not on there, then it'll be in specific performance, section number 11. This is in Texas. And that can be scratched out. So the date, a correction of the name during the negotiation can be corrected. Things like that can be scratched out, but not the original text of a contract. These are typically things that we write into the contract based on the questions we ask a seller and a buyer. Then we fill in. As a realtor, we cannot scratch out any clauses. We can scratch out, or the seller can scratch out. So this might have been a buyer seller on their own. Okay. So it is considered a counter offer. So keep in mind, it'll typically be something that's in the fill in the blanks that is scratched out, because a contract doesn't typically have, oh, seller will pay for buyer's closing costs. We have to fill in a blank that says, okay, buyer wants so much money, ask seller for so much money for buyer closing costs. Okay, it'll be a blank in. All right, did I type the answer? So the answer there was C, a counter offer. So tag, that's a very good question. However, anything that is in a blank space that was filled in, that can be scratched out. And then both parties must initial when they come to a mutual agreement. If they don't come to a mutual agreement, so the seller sends it back, scratched out the buyer closing costs for the inspection at closing. And if the buyer doesn't agree, then it never became a contract because they never came to a mutual agreement, right? So it stayed in the negotiation phase and never came to fruition. Okay, so that was it for national questions before text date questions. For those of you that are on YouTube, hey, thank you for the thumbs up. And if you haven't clicked the thumbs up on my YouTube, thumbs up if you found this video useful. If you didn't, hey, no thumbs down. Don't say anything negative, okay? Just don't fill it up. Don't do a thumbs down, you know. Hey, we can't satisfy everyone, right? But you have a choice. I shouldn't say, and we have a choice. All right. Gotcha. Yeah, I like your words. I like to create some, some laughter, some, things like that. Lots of thumbs up. Yes. Thank you. Thank you. Thank you. I greatly appreciate it. So any questions before we text? And if you missed any of it, you can go on video, any of those, and vocabulary questions and answers, and a few topics. And then I have some videos there to study, or there's 8 pros, 8 cons on one of them. I have 8 tips to help you study, and then other tips prior to going into the exam. And on my Facebook group, if you're a member of my AgentPrep private Facebook group, I have other documents in there that you can download that I've collected from other students or other individuals. And one of them is cheat sheet for the night before the exam. That one's really good. I was told by several of my students. So you can go to my private Facebook, automatically join, however you include the email and your name, and you agree to follow the rules. And then you answer whether you're going to do this full time or not. So because I finally decided I'm not going to let just anybody in. There are a lot of spammers that they come into my group, as in YouTube, and start promoting some other people. And that's not cool. All right, so let's see. Oh, thank you, Ms. Page. Have fun. Yes, I just joined your Facebook group. Yeah, the name. Okay. I look forward to the files. Yes, I have. There are under the section guides. I have 14 guides in there. One of them is a very old book called The Texas Real Estate Sales Exam, 4th edition. It's free online. My students back in 2014 let me know about it. So it was published in 2007. That book is excellent because it has vocabulary, it has questions, it has the answers explanatory, and then after each exam, there are 4 exams on there. It categorizes the questions per topic. So let's say you miss several questions on brokerage responsibilities. Okay, then you can go look for that category on that one page and see, oh, I got to go back and review these particular questions. Most prep books don't have it. I wish that author was still creating the book, but they're not. So that book is free online, or you can go to my Facebook group or click the link in the description below and download it. If you want the one with the CD, you can purchase it from Amazon, and just know that should you purchase anything from Amazon, I'll get a little fee because I am an affiliate. Yes, so the group here, thank you for sharing that page. It's the AgentPrep Real Estate Exam Prep Group with Wild Lillie Handy. It's a private group, okay? Not just anybody. Oh, so you see the guides. Awesome. Yeah, there are 14 of them. So you'll have to click it twice. You click on the guide, then it opens the post, and then you got to click on the PDF to download it. I recommend that Texas Real Estate Sales Exam 4th edition. Even though it says Texas, the national portion is excellent. The vocabulary, the Scantron, and the review of the topics that you did. So I highly recommend that everyone, have a prep book that you maybe purchased during taking your classes. And if you didn't, buy a prep book. You can use one of the ones that I recommend in the descriptions, or get it from a friend, or buy a used one. Save your money for when you start the actual business. You'll need it. Okay, thank you very much. So we're moving into Texas State questions. And I've had many other students ask me if I could do other states. I haven't bought the books, and that means I would have to go live more times. Pre-record. And upload them. Which I've been thinking about that. Because there's other websites, other YouTube channels that end up doing, state questions for all 50 states. And they have lots of followers. My channel grows slower than those that do that because they're attracting every single state. But I haven't looked to see if their 50 questions or 80 questions include national and state, or if they're just state specific. However, I have noticed that they have lots of subscribers. A source is Prep Agent. Okay, he predominantly does national on YouTube, sometimes does some state, and then you can buy his website to have other sources, and a tutor. I also do tutor, and for that I have begun to charge. So that would be one-on-one using Zoom. So if this is your first time to my YouTube channel, YouTube AgentPrep, hey, you know what to do, right? Tap that subscribe button, click that little bell so you're the first to get notified every time I go live. And like this video, thumbs up, and send me some love should you find this video, this class useful. All right, we're moving on to Texas state questions. Let me change my screen over here. And for anyone who, just to refresh, and anyone that is new, come on. Okay, this is the book that we use, that I have approval from the author. Texas Real Estate License Exam. It is published in 26 different states. Has national questions and state questions. All right, there. So let's go back. Buy the online book that we can read it on Kindle.
Hi, Lily. Thank you.
Good night. Good night, Bailey. No BM.
Okay.
All right. So we're not doing that. We're starting topics in Texas real estate. So bear with me as I pull up my answers in case I need them. Okay, so if anybody has the book, the answers are on page, oops. The answers are on page 19. So for Texas state, I do less questions, right? Because we only have 40 state questions. And so the books have fewer questions available than we do for national. Because for national, we have, what, 85 questions. And they're basically the same questions for realtor, sales agents, and brokers. That brokers get graded on more questions versus on the national. Well, on the national notice, we have to get a 7 out of 5. Well, we get graded on 80. Brokers get graded on 85, and on the Texas state, sales agents get graded on 30. So you get a 70 out of 30. So you have to answer 21 correct. And for the broker exam, gosh. Lordy Lord. Texas state. Sound like a broken record? Yeah, huh? All right, Texas is a state out of 50 that are community property. Little different than tenants by the entirety. It's one of the type of ownerships, right? So Texas is a community property state. Effectively, this means that once married, gosh, my screen keeps going on and off. Okay, once married, all property is owned equally between husband and wife. B, upon legal marriage, all property becomes owned as tenancy in common. That's one of the other types of ownership, right? C, spouses, with some exceptions, share property acquired during the marriage acquired following marriage becomes jointly owned without exception. So what is community property in Texas? It's one of the 4 ownership, right? We have severalty, tenants in common, joint tenancy, and in Texas, community property. So type your answer in the chat. Which one will it be? All right, so far we have 1C. One else. All right, we got C, C, C. C, C, oui, oui, monsieur. So yes, number 1 is C. Spouses, with some exceptions, share property acquired during the marriage, but not what each owned beforehand. So if they have, if spouses end up gaining property as a gift after marriage, okay, it wasn't just it. A gift belongs to the one individual. Okay, it was gifted to both, then it belongs to both. Or if one of the spouses ends up getting an insurance claim for hundreds of thousands of dollars and they use it to buy property, bought it with that money is not community property. Okay, if injured or major accident and ended up collecting a lot of money, okay, those are exceptions. So anything purchased beforehand is not community property. Let's say they have rentals and they get married, and those rentals are not in an entity where the entity deals with all the expenses, all the income. It's never commingled in the marriage. If it's not in an entity and it's under the individual's name prior to they bought it, during the marriage, any rent that comes in from that property is community property. Why? Because it is being earned during the marriage. So any type of income like that, okay, that's earned during the marriage is community property. So keep that in mind. Did anyone know that? That if someone owns property before marriage and they get married and any rent that they collect becomes community property, as long as it's not in an entity. So many individuals that get married, divorced, for the most part, we will put them under an entity or have multiple assets protection, right? So they bypass having to do what is called a, what do you call it? Gosh, forget the name. A document that you sign prior to marriage so that you don't get the rights to whatever they own. Jeez, I can't remember what it's called. And gee, it came to my tongue and I can't spell it out. What's it called when individuals have to, let's say somebody marries a millionaire and that millionaire doesn't want to lose those assets to a spouse that they might be married 1 year. What's a document that they end up signing? A prenup. Yes, a prenuptial agreement. Yeah, thank you here. Praid said a prenup. Yeah, prenup. Thank you, thank you, thank you. See, when it's not words that we use regularly, hey, they're not important because I haven't dealt with them. All right. Thank you for your help. Numbers 2. Oh, Lisbeth wants me to move on. She already answered 2. A husband in a community property state acquires a vacation property as a family gift. A property as a family gift on the first anniversary. What is the ownership status of that property? A, each spouse owns half of the property. B, the wife owns half of the property but must forfeit her share if she divorces. C, the property is shared since the conveyance was not via an inheritance. Or D, the husband owns 100% of the gift. Okay, page. What is HA? That's a good sign. That's a good sign. Oh, the prenup? I'm not sure what what you're referring to. So, hey, Mr. or Mrs. Tag, remember to type the question number in addition to the letter answer. Thank you. That way we all know, because sometimes there's delays, and so I don't know which question you're answering. Oh, yes. Oh, yeah. That's my prenup. Yeah, right. That's a good sign that they may not stay married. At least that's what, the Bible says, right? Well, I'm not sure it specifies that would fail. Or that it could fail. Yeah, the gift that is given while they're married is by the husband. Okay, let's see. Prenup, that you didn't have to say that often. Yeah, that's right, right? I don't have to say it that often. I've been married more than once. Okay, never had one. And I ended up with a debt and at least a couple marriages. My brother's the dummy you, right? Oh, well, I was financially responsible. That happens. All right, number 3. So gifts are not community credit, and insurance claims from a personal injury. That is not community property. There's probably other things, but those two are not. All right, number 3. Which of the following is not an accurate characteristic of homestead law? So what is homestead? What is a characteristic? So what is not an accurate characteristic of homestead laws? A, homestead rights require a one-time filing with the county clerk. B, homestead interests are extinguished if the property is sold. C, the family must occupy the residence to qualify for the homestead. Or D, homestead property can only be voluntarily conveyed by both spouses. So there's one that is not accurate. So which one might that be? Certain things are, well, I better not say, because I may give a clue to the answer. All right. No, it is not D. Homestead. We can only have one homestead in the US, right? If we have one in Texas, we can't have it anywhere else. And it has to be for our primary residence. So which one is not accurate? Okay, we answered D. D says homestead property can only be voluntarily conveyed by both properties. Okay, that is a true statement. Both individuals, okay, that are married or own the home have to sign in order to convey it voluntarily. So the answer is A, homestead rights require a one-time filing with the county clerk. No, homestead is a legal right provided by the state or by states that have homestead laws. The owners of that home, that is their primary residence, from certain creditors. And then it doesn't have to be filed. It's legal. It's automatic. What is not automatic is the exemption, to get an exemption from paying all the taxes. So by going to the county, from the county tax assessor's office, then they file a form and say, hey, I want to take advantage of the tax reduction of certain sections of the property taxes assessed. So that is not automatic. And because I know several clients that I used to have, I would go look at the county appraisal district website, which we do very often when we're dealing with sellers and buyers, and it's free to everyone. It's public, public information. It'll say on there, if they have applied for the homestead exemption, it'll say HS exemption. One of the exemptions is homestead. They'll get a reduction on a portion, just a portion of their property, their assessed property taxes. Now, other exemptions is you're 65 and older, or you're a veteran, disabled veteran. The homestead is automatic for a primary residence in Texas. What is not automatic is getting the exemption and having the tax reduction. The exemption is automatic. However, in order to get the reduction in taxes, we do have to go and fill out a form and say, hey, I want my money, right? They don't do that automatically. And okay, it doesn't say that they're tenants in common or joint tenants that purchase the property, and they don't have to be married, yet they all live there. That's their primary residence. We can only have one. Number 16, 14, and let's see, did anybody get voluntarily? That's a true statement. It has to be conveyed when they are married. Not all homestead situations are married situations, right? Because there's 4 types of ownerships. Severalty, one person. Well, he doesn't have to sign with a spouse because it's one person or an entity. However, it doesn't apply to an entity. It applies to an individual. Tenants in common. So you could have 2 individuals living together and they purchased it together and they own it 50-50 or 30-70, 60-40, or whatever other percentage. It's their primary residence. They both still have to sign in order to sell that property, even though they're not married. Or one might decide to sell it and not the other one, right? And then homestead interests are extinguished when if the property is sold. Yes, the homestead is with the individuals that purchase the home. It's the primary residence. So it goes bye-bye once they sell, because the next person might be an investor. It's not a homestead for investors because they're using it as income property to rent it out and have it as a tax shelter. Okay. And you're going to say, what the heck is a tax shelter? When we make investments and we have lots of expenses to lower our income taxes, those are tax shelters. A Roth IRA, an IRA, individual retirement account, a 401k, 403b. Those are all tax shelters or government taxes, income tax. All right, number 4. Which of the following best describes a homestead tax exemption? I just said that. A, an exemption from property taxation of portions of the homestead assessed value. B, a direct reduction in the homestead property taxes by a certain percentage. C, a homestead property is exempt from taxation. D, a homestead property's equity is exempt from taxation. So I just basically gave you the answer and the explanation of number 3. Excuse me. Type your answer in the chat. So which one best describes? Sometimes there's a couple answers that seem like they could be right. And then you have to say, which one is the best answer of the options? It is not B. It is not a direct reduction. It doesn't deduct a percentage of the whole assessed taxes. It's only from parts of it. Okay, so the answer is A, an exemption from property taxation of portions of the homestead's assessed value. So there's different taxations, you know, the school district, the city, the roads, and you know, trash and sewer, you know, things like that are part of the assessed value, and each one has a rate or percentage. And when they're all totaled together, you know, they could be a rate of 2.9% for every thousands, okay, of the purchase of the price, not the purchase price, of the assessed value. Well, the exemption doesn't happen on the complete assessed value, only on certain portions of the assessed value. Okay, so it's not a direct reduction in homestead property taxes. That means you would be taking, if the taxes are 5,000 and they say, okay, the homestead exemption is 20%, they would take 20% from the 5,000. No, from the 5,000, it'll be, you know, usually it's on other things other than the city. The city is usually the highest tax that we pay, and schools. So they'll take a portion of it from some of those categories, not all. So the answer is A. So we had 2 B's, which said a direct reduction. No, it's a portion of the assessed value. And they go and apply for that exemption. The homestead is automatic. It's illegal. I'm not illegal. It is legal already by the state. Make sure I type the. All right, number 5. Which of the following is an accurate homestead tax exemption statement? And it may not be exact according to how it's stated in the homestead laws. I had somebody question this and says, no, that is not exactly what is stated in the home tax exemption laws. And I went and looked it up, and it's true. But based on the questions and the answers that are offered here, we go with the best one. So which of the following is an accurate homestead tax exemption? A, 10,000 exemption for county purposes. B, a 15,000 exemption for school districts. C, the standard homestead amounts are granted to each family member resident. Or D, disabled persons can receive more than one resident's homestead in a year. And one of the things, some counties, they don't have county taxes. That's why people want to live out in the county, because they don't, well, excuse me, let me rephrase that. They don't pay city taxes when they live in the county. So county taxes are lower than city taxes. I just wanted to point that out. All right, so we have B, 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 and yes, that is correct. The answer is B. according to the answers available here. Yet it's different stated. If you look up the homestead laws, you're going to see a different amount. So it is B, a 15,000 exemption from school districts. Like in Texas, I think we have, they changed it from 15,000 to 25,000 as a tax exemption. What am I typing? So the 20% only from different tax tax, because sometimes there's like 7, 8 different assessed taxes. Yes, indeed, more taxes in the city. Yes, definitely. Why? Because we have a more demanding infrastructure. We have higher density of people. And in the county, we have lower density, okay? And they don't provide as much services. Like in the city, they'll pick up the trash and recyclables. In the county, we have to pay to have the trash and all that picked up. I know, because I lived in the county in South Texas and when I lived in Oregon. So that's paid to waste management, right? But in the city, that's part of our city taxes. All right, so we started with number, we'll do a couple more. We started with 16.1. What are we on? 16.6. Okay, that's a long one. So I'll tell you what I used to do in the exam. Since I was a slow reader, I would click the long questions for review and do all the other ones quickly and come back. Oh, and that we go to the exam. Prep books recommend to skip the first 5 questions because they're usually the hard to get you nervous, and skip the math and come back to them after you do all the easier questions that you're comfortable answering. Then make sure you come back and answer the first 5 questions and all the math. So let's see. School and more population. Schools. Yes, right. In the city. So, right. So that's why we pay taxes for different schools. It could be for the university, for the school district, for other colleges. So sometimes there's different schools listed in there. All right, number 16. Following the tax sale in a foreclosure proceeding. Okay, foreclosure. Following the tax sale. What kind of sale? Tax sale in a foreclosure proceeding. A homeowner can regain full ownership of the property by paying all the amounts owed, plus fees and charges. In this scenario, which of the following is true? So be very careful. This is not the normal foreclosure of a home. It's what tax sale foreclosure. So A, the homeowner may do this since he is exercising his equitable right of redemption. B, the homeowner may only exercise a statutory right of redemption prior to the tax sale. Or C, the homeowner may in fact exercise this statutory right of redemption provided the property is their principal residence. Or D, the homeowner may exercise the statutory right of redemption provided it is done within 3 years of the tax sale. Okay, so there is a tax redemption law in Texas. How many, do you know how many years that is? So we've got so far one answer of C by tag. So that means tag you're it to pass your exam now. You've been tagged, or it's like tagging somebody in social media. You know, it took me forever to understand how to do tagging, and I don't do it much. Tag 2. What is 2? 1, 2, buckled my shoes. Not sure what the 2 is. So you answered 6C. And yes, the answer is C. The homeowner may in fact exercise this statutory right of redemption, provided the property is the principal residence. Yeah, the tax sale is on their principal residence, and they have 2 years to redeem that property. And it says, now on that, they don't say, but on one of the other ones, it says they have to pay exercise. No, it doesn't say that. So anyone that has a property that they lost it because of taxes that were due, property taxes that were due, they have 2 years, statute of redemption, statute of law, to redeem that property. The first year, so investors buy these properties, right? And they keep them, they hold on to them for 2 years because they bought them for a low price, only the property taxes. If it has a property on it, they can rent it. However, they can't sell it for 2 years, but they can earn money from it. And when the owner decides they want the property back, they have to pay 25% interest of the total plus all the other costs the first year. On the second year, if they redeem it, they're paying 50% interest on the total that the investor paid, court costs, attorney fees, any other fees that are due. So that's why investors. All right, so ta'i. So ta'i is the H silent. Nice. I'm thinking it's ta'i. All right, so number 6 is C. Shoot. Y'all are doing great. Everybody got that? Number 7. And these were what special topics, right? Number 7. Which of the following agreements are enforceable? Well, let me make it larger. Dang. Come on, it's like right in between. Nothing. Okay, there's a little better. Which of the following agreements are enforceable? A verbal 30-day month-to-month lease. B, an oral agreement to buy an oil interest in a property. C, a written lease signed by the landlord's son and unauthorized representative. Or D, an oral property conveyance between a judge and a juror. So which agreement is enforceable? Remember, majority of contracts have to be in writing in order to be enforceable. So what kind of an agreement does not have to be in writing in order to be enforceable? Your answer in the chat. Here's another interruption. Okay, so far we've got 7A. Let's see. Tai, it's not B. Take another attempt. This is the time to take a risk. All right, we have A, B, B. Oh, no. Oh, Paige, don't doubt yourself, because the answer is actually A. You had it right. So it is a verbal 30-day month-to-month lease, right? Lease can be enforceable, right? Those type of oral agreements are enforceable. The other one, an oral agreement to buy an oil interest in a property, no. That's buying the mineral rights. And see, a written lease signed by the landlord's son and unauthorized representative. Number D, did anybody answer D? No, it was just A or B. So an oral property conveyance between a judge and a juror, no. Okay, those things have to be in writing. So the only one is a verbal 30-day month-to-month lease, right? So it's reoccurring. Okay, so that's a leasehold that reoccurs. Yes, your first guess was right, Paige. She said, ha, 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 I knew it. Yes. That's when we trust our God feeling. I'm sorry, intuition. Some people don't believe in intuition and gut feeling, but let me tell you, animals have intuition. It's an instinct, right? We also have instincts. So your first guess was right. A verbal is oral, 30-day month-to-month lease. That is absolutely correct. The others are not enforceable. Okay, because the oil interest, okay, and mineral rights can be sold separately than the land and the improvements. Many farmers, when they sell their land, they want to keep the mineral rights because there could be oil sometime in the future, or other types of minerals or water, right? And then a lease agreement signed by an unauthorized person is not enforceable. And then oral property conveyance, conveyance are done in writing. All right, and questions on these Texas state questions. This is the last question for today. This is the time to ask. And that's great that all of you are here preparing. Typically I would say study in 20-minute sessions or 25-minute sessions. There's a Pomodoro tomato that it is an alarm clock that they call it the Pomodoro tomato. It's a timer so that you can see 20 sessions done, and it's 20-minute sessions. And why is that? Because the mind remembers the beginning and the end of every study session. So what you want to do right after this is take a break, okay? Because you're not going to remember everything that I went through, because we went 2 hours through this, and some of you weren't here 2 hours, okay? The best way to study, okay, is in a comfortable, quiet place for yourself. You can have your own music, classical music. Put your own cologne on that makes you feel good. I use a diffuser. It ran out, with lemon and orange citrus that livens me up, energetic. All these different things will help you study, and studying in short spurts. Like when we go to school, right? We have 50-minute classes and they start getting bored, right? And they have 10 minutes in between each class. So here we recommend 20, or Jim Quick recommends 20-minute study sessions. Take a 1 to 3 minute break. Drink water, stand up, stretch, walk around a little bit, go to the bathroom, and come back and study another 20 minutes. I actually started making it a practice because I do cold calling in the morning, and that's another good thing to do. So I set my timer for 20 minutes and I take a 1 to 3 minute break, right? So let's see. Oh, hey, Homemade Hospitality. How you doing? Hey, Cassie. We missed you tonight. You test on Thursday. Awesome. Is this your first time, second time? Which time is it? So Cassie is testing on Thursday. So remember to go to my Facebook prep book. Texas Agent Prep Real Estate Exam Prep Facebook group, the private Facebook group, if you're a member there, and download the exam cheat sheet. It's called the night before the exam cheat sheet. That the night before, and try to go to bed early, get some good sleep, and the next day don't drink a lot of coffee or any of those high energy unless you think you really need it, because it makes us nervous, you know. And you want to go in there and let's see, click for review the first 5 questions and the math, because those are usually the more difficult questions and they can get you anxious and scared for the rest of it. Go do all the easy questions first. Click the ones that you're uncomfortable with or you don't know at all for review. A future question sometimes helps you answer a prior question. All right. So this is your first time. Awesome. I'm glad you're taking it. So I hope that so I recommend that you study every day. Okay. At least, a couple hours or however much time, but take a break every 20 minutes or 20 to 30 minutes. You're welcome. And so Paige, Cassie says, thanks to Paige. And so it's your first time. And you will also, so Ty, you're going to be taking your, yes, you're in Tennessee. Yes. So in Tennessee, do you have 1 exam or 2? Is the national and the Texas and the Tennessee state separate? Here in Texas, we have it separate. It's 2 different exams. So, so I use the practice test. Yes, I has. Awesome. And after that, I'm resting. Nothing after Wednesday at 12. All right. Good. Yeah, because when we do a crash, what do you call it? Crash the night before, right? A crash study. We can get even more anxious, more antsy if we don't know certain answers, and that just screws it up for the next day. Go early, drink your water, relax, go with time. Before you go into the exam, close your eyes, take several deep breaths, and focus on the fact that you passed that exam. Ask for guidance. Ask, believe, and receive. Breathing several times deeply, holding it and releasing it helps you relax your shoulders, your body. Don't tense up. Okay. Relax everything. And before you go in, tell yourself, I've got this. I passed. Okay. And awesome. So you have 2 separate tests in Tennessee. And Thai, you're in Dallas. Okay, so you will have 2 exams. And Paige, you're not committing for a test yet. Oh, thank you, Thai. I greatly appreciate it. I'm happy to hear that you like my style. Yes, amen. Yes, don't cram for the test. Amen. Believe. Yes, I believe. Be grateful. And if for some, you have a 50-50 chance to pass. If for some reason you don't pass, I know you're going to be disappointed and frustrated, and that's okay. All right. It really is. Go back and study. If you have to reorganize your study, do something different. Okay. And be serious about your commitment to study and being what it takes. It takes work. If it was easy, everybody would be passing it. All right. And it doesn't have to be hard. That's why I explained the questions in detail. Yes, praying all the way. I do too. dear God, I ask you to bring her an easy exam to Cassie. Some of the exams are easy, right? And that she remembers everything and passes that exam. All right, awesome. I wish you the best on that day. And why can't you hear me? Let's see, why can't I hear you? I hear you. Okay. Yeah, because the internet is interrupting. Okay, and so my StreamYard, and even on my YouTube right now, on YouTube, I have the little wheel of death, which we call in Apple computers. So there's been a lot of internet interruption, even though I have high speed internet. So Judy Lynn Floyd will test on the for the second time, February 14th. Oh my gosh, on Valentine's Day. Oh my gosh. So study every day. Okay. Minimum 20 minutes, actually more, but 20 minutes at a time. If you do it 30, make sure you take, 2 to 3 to 4 minute breaks. Okay. And, affirm every day. Focus and, meditate on it. And it doesn't have to be long meditating. Just close your eyes and see yourself. I passed it, man. I passed it. I did that when I wanted to win a trip to Hawaii. I did that every day for 2 weeks straight. And guess what? I believed it. I cut out a picture of me already scuba diving and winning the trip. And I won the trip. No, I'm not able to make that happen all the time. But I meditated, I focused, and I said, I won. It's mine. And I believed it. I asked for it. I believed it. And I verbalized it. Okay. And it happened. So I got it now. Yes, you got it. Thank you. I had so much fun. You're welcome, Paige. That's awesome. I appreciate it. And then Judy Lynn says, I watch you all the time. You have helped so much. Oh, thank you so much. That goes to my heart. It really does. Because there are people that don't like my style, right? However, I've been doing this for over 8 years, and I've learned that I need to explain the questions more and the answers. Because you know what? I even understand them better. And I point out the keywords and little things to pay attention. Yes. I don't usually use it. Some people don't believe in manifest. Okay. But God provided our mind, right? To believe. And he made things happen. Not everyone's a Christian, a believer, but I do believe, and I believe. So I ask, believe, and receive, and I give God thanks. And I'm grateful many times during the day. So I am grateful for all of you. Because of you, I continue to do this. And I'm so thankful that you're here with me during these sessions and that you're going to pass, right? And so let's all repeat what I love. On the count of 3, we're going to say, I passed 3 times. Say it at your home. I passed, I passed, I passed, and you pass. Awesome. I just started watching and love this so much more than actual real estate. Cool. Yeah. Well, there they have to be strict and, follow a time, and, they have so much to cover. Mine, I have the leisure, and I've been learning from my students attending on how to better improve it. Thank you all so very much. Take a break after this, drink water, walk around, go outside. Weather's nice here in Texas. So again, this is Wild Lillie Handy coming to you from San Antonio, Texas, with whom? YouTube AgentPrep. I'm also on Facebook, a private group. You can download information from there that I've collected from other students and other places, other sites. Until next time, catch you all later. Have a good night. Have an awesome night. One of my popular words.